Good afternoon. Committee on Judiciary and Hawaiian Affairs called to order. It's Wednesday, February 10th, 2 o'clock in conference room 325. Okay, first bill on the agenda today is House Bill 245 related to historic preservation. Um, First up, we have Kamakana Ferreira, Office of Hawaiian Affairs.
Aloha Chair Nakashima and members of the committee. Uh, my name is Kamakana Ferreira. I'm the lead compliance specialist with the Office of Foreign Affairs and providing the administrative testimony. We stand by our written testimony, but we'd like to flag that we do have suggested language that we believe will minimize possible exclusion of Native Hawaiian sites from the proposed amendment. Notably, the eligibility for the HRHP does not include specifically a criteria for sites that are important to Native Hawaiians, whereas the existing 60 process does. So we want to make sure that they're not left out. And we're available for any questions. Thank you.
Okay, thank you very much. Next, Ellen Downer, DLNR.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Alan Downer. I'm the administrator for the State Historic Preservation Division within DLNR, and the department stands on its written testimony, and happy to answer any questions if the committee has any.
Okay. Thank you very much. Next, you have Lorraine Minatoshi Architects. Not present. Okay. And that's all the testimony that we have for this bill. Are the uh, members any questions for our testifiers? Okay, seeing none, we'll move on. A short recess, please. Okay, calling back to order. Um, yeah, members, I'd like to take one of the bills out of order. Um, House Bill 838. Relating to the Hawaiian Civil Rights Commission. Um, First up on the agenda there, Robin Wurtzel, Hawaii Civil Rights Commission.
Thank you, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. The Civil Rights Commission stands on our testimony in strong support of this bill, House Bill 838, House Draft 1. We do have serious concerns over the diminished enforcement capacity and the addition of new protected bases, but we are in strong support of this bill nonetheless. I'm available for any questions. I think our testimony explains it, but I am available for questions since it's somewhat confusing.
Okay, thank you very much. Next, Peter Fritz.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Peter Fritz. I will stand on my written testimony in support. I was personally affected by the change in the Supreme Court decision, as I had a pending complaint against an agency be dismissed because of a lack of jurisdiction. So I think that a remedy should be restored to anyone, a state remedy, rather than having to go through a more complicated federal remedy. Thank you for the opportunity to support.
Thank you very much, Mr. Fritz. And last, we have Linda Ilento.
Let's see. Aloha, this is Linda Ilento. Can you hear me?
Yes, we can.
Okay, great. Sorry, you caught me. I have to pick up a student from school and didn't expect this to be heard so soon. So I apologize for that. But I am Linda Ilento. I'm several years ago, I took my son's complaint from a charter school and I presented it to the Civil Rights Commission. And I was hoping they would help me per the 368-1.5, but I was told because my son's a special ed student, they could not help my son. So I challenged the commission and said, well, you guys can help everybody else, you can help my kid. So it was a surprise. We all ended up in the Supreme Court, where they decided that the federally funded programs are covered under Section 504. Those cases would not be included. So people like for Mr. Fritz, they all of a sudden were not covered anymore, expecting the help they needed from the Civil Rights Commission. So basically, I feel like I'm back to where I was presented these facts, and what I'm bringing up, I have provided some testimony, and I would appreciate the opportunity, and I will be asking more questions to, like Ms. Wurzel. We've talked about, or Wurzel, sorry, about what does it mean, the scope of the IDEA for special education. I'd like to point out at the moment that there are two recent cases. One in particular is Fry versus Napoleon, where I believe it was either Supreme Court, at least the Ninth Circuit. Maybe I don't have it, but it's in one of my written notes testimony for another committee. And a complaint or a valid claim under IDEA is strictly regarding faith, free, appropriate public education. That is not the same as a disability discrimination complaint, which would be based on Section 504 and ADA Title II. So what I want to convey here, it is not necessary to include any language excluding IDEA, because we're talking apples and oranges here. I can have a complaint because it's a special ed child, that's what's going to be looked at. Oh, special ed, IDEA, we can't help you. This has been our lives as parents and children, for me personally, for almost 20 years now. We can have a valid Section 504 complaint, and this will be very confusing to people to see IDEA, oh, we can't touch this complaint, and yet we can have very valid complaints that would be covered under 368-1.5. And if you look at 368D a couple years ago, it was added that gender protection was under education. So one of the bills that is on the table that hasn't been heard yet is SB 1331, and it was referred to education. So I'm hoping they'll hear it along with HMS. But it specifically simply states adding students with disabilities. And I know I could provide more for you, but yes, I'm not able to provide more details at the moment, but I am available for questions. I'd be glad to provide more information in writing or in any form. So I'd appreciate your consideration and asking more questions to the commission. What do you mean by scope of the IDEA? Thank you very much for your consideration.
Thank you very much. Okay, that's all the testifiers that we have.
Thank you.
All the testifiers that we have.
Oh, sir,
For this bill. Are there
I
any
was just,
questions?
okay. I'm still connected. Can I add one more thing? I mentioned there were two cases, the Fry versus Napoleon. Forgot to mention another case. This one did get, well, it's called KM versus Tustin. So those are just two for the record. So for spelling KM versus Tustin, TUSTIN. Thank you again.
All right, members, any questions, Representative Ward?
Chair, hopefully she's driving safely. She's a multitasker. Mr. Peter Fritz, are you still there? I have a question to you.
I'm back.
You are back. Could you give me in street language how this bill affects you or didn't affect you when you had a discrimination case?
Sure. I had filed a discrimination case against an agency. The agency posted its notice 6 days in advance, but in the notice itself, it said you must make a request for an accommodation 10 days in advance. So by the time they posted the notice, there was not enough time left to make a request for an accommodation. The complaint was filed with the Hawaii Civil Rights Commission, but then the Supreme Court made its decision, and because of the decision by the Supreme Court, that complaint couldn't proceed any further. Under state law, it could have gone to federal law, but that would have required filing a complaint in federal court or with an administrative agency in Seattle. And for simple things such as making a change to policy, it seemed like it was overkill. So I did not pursue it any further. Does that answer your question, Representative?
So this bill will do what for you?
The Supreme Court's decision said that any agency that receives certain funds, you could not sue them under state law because your sole remedy was under federal law. So this bill would restore the right and take away that necessity of, take away the fact that they had federal law being a defense, federal funds as being a defense against filing a discrimination suit under state law. So it gives that to the Hawaii Civil Rights Commission, which provides an opportunity for people to bring an action under state law.
Okay, got it.
It kind of reverses the Supreme Court decision.
Yeah, exactly. Thank you, Mr. Fritz. Thank you, Chair.
Thank you.
Members, any other questions?
Mr. Chair,
Yes.
could you clarify, are we on HB 344?
We are on HB 838.
I'm looking at the wrong agenda. I'm sorry. Thank you.
Sorry, we think we're taking this bill out of order.
Oh, okay. I was very confused. Thank you.
Chair, if I might make one comment.
Yes, Ms. Wurzel.
So this bill actually returns the statute to the way it was interpreted prior to the Supreme Court decision matter of LE. It just brings it back to the way that it had been interpreted for many, many years, which would allow us to accept cases against state and state-funded agencies. By the Supreme Court, when they limited it to agencies that don't receive federal funds, it eliminated all state agencies. Almost, well, there may be one, but almost all state agencies receive some federal funds. And there may be some nonprofits which receive state funds that don't, but it made the interpretation, which didn't receive a lot of cases anyway, but it made it so narrow that we actually haven't had a 368 1.5 case since that Supreme Court case.
Okay. Yeah. Representative Matayoshi.
Yeah, Robin, maybe I'm misunderstanding, and I apologize if I am, but.
No, it's okay. It's confusing.
So it seems like the Hawaii Supreme Court ruled that if there was federal funding, then it should go to federal court, because I'm assuming of federal supremacy and jurisdictional matters. Kind of thing. Is that not what they ruled on?
Not exactly. What I think that they were, well, based on the questions that they asked us during argument, so I can't speak for the Supreme Court because it wasn't in their holding, but based on the questions that they asked, I believe what they were doing was trying to narrow our jurisdiction so that people couldn't bring IDEA cases under here. It's not so much a question of supremacy, because there are many state laws that mimic federal laws. Even the criminal code allows us to bring most cases under the state criminal code. Certainly the discrimination laws do. The Civil Rights Commission has jurisdiction over cases under Chapter 378, which is employment, and there are federal laws, and you can go to the EEOC. It just gives you two places to go, one of which is simpler for many people. So this, and because there is no, as Mr. Fritz pointed out, there is no local agency that you can complain to regarding federal violations. You either have to sue in federal court, so there's no administrative process, or you can go to the OFCCP, Office of Civil Rights Compliance in Seattle, which is a really small office and difficult for people here. I mean, for one thing, there's a time difference. I mean, so the fact that there are two, that we could have state laws that are similar to federal laws is pretty common.
Okay, I might touch base with you on this later.
Okay, I mean, and I'd be happy to explain it to you. It's just, we have duplicate laws regarding discrimination for almost everything. Public accommodations, housing, yeah.
Okay, members, any other questions? Okay, if not, thank you very much, and we will move on to the next item on the agenda, House Bill 344 relating to government. And first up is Ron Miley, Judiciary. Oh, I'm sorry. Next, we have Kaleo Manuel, DLNR.
I'll speak for DLNR. This is Suzanne Case, DLNR Chair, and we stand on our written testimony in support. Thank you.
Okay. Ms. Case, are the other DLNR staff going to speak, Kaleo Manuel or Bob?
We're here to answer questions. Yes.
Okay, thank you. Next, Henry Curtis, Life of the Land. Not present. Laulani Teal.
I'm here. Aloha. Can you hear me?
Yes.
Aloha. My name is Laulani Teal. I'm a public health worker and a peace worker in our community. I've worked with many, many land protection issues, many of which have started with a contested case. And I have to say that I want to register my very strong opposition to this measure. I believe that the public, and particularly Indigenous land protectors, really, really need a civil process, such as a contested case, to attempt to work with the state, despite issues that may exist, in a peaceable and civil manner, in order to achieve resolution of those issues. Without this process, they would be forced to either go directly to court if they have the means to do so, or if they don't have the means to do so, to take direct action. And honestly, if it is down to those choices, what will happen is that there will be a lot more direct action. And while DLNR is simultaneously being militarized, quite honestly, we could expect to see severe brutality and clashes that would result in very, very serious conflict. And I am saying this as a professional mediator, peacemaker, and Ho'oponopono practitioner in our community, who has seen a lot of conflict over the 3 decades that I have been doing this work. So I ask you to please keep our civil process in place right now. We may not all agree on many of the issues that come before us, but what we should agree on is that people should have an opportunity, given where they're at right now in this time in history, to work out their differences in a civil manner with full participation of the community. Mahalo nui loa, aloha.
Thank you. Next, we have M. Elani Sonoda Pale.
Aloha, Chair Nakashima. Aloha. I'm Helani Sonoda Pale with Kalahui, Hawaii, Komike Kalai Aina. We submitted our testimony in strong opposition to House Bill 344, which eliminates contested case hearings for land and water disputes under the BLNR, the counties and the Water Resource Management Commission. If this bill passed, it would remove our right to contested case hearing, a quasi judicial process, and everyone's ability to challenge critical land and water use and other government agencies' decisions that negatively affect our environment and ohana. Important native land use cases began with a contested case hearing, Pash, Kapa'akai, and they were originally brought by Kanaka Maoli, whose rights and interests in the land and water were being threatened, and they eventually found their way to the Supreme Court of Hawaii. With no contested case hearings, there is no due process, no record to appeal into a court of law, thus making this proposed law unconstitutional. Kalahui Hawaii also stands behind the testimony of Mauna Kea Mokunui Ailike Consensus Building Ohana. And I also I'm authorized to speak on behalf of Uncle Paul Nevis with the Royal Order of Kamehameha, and he's also with Mauna Kea Nainaho. He is in opposition to this as well. Thank you.
Thank you very much. Isaac Moriwaki.
Yes, President. Aloha, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. Isaac Moriwaki. I'm an attorney with the nonprofit environmental law firm Earth Justice here in Hawaii. We submitted strong testimony, strong opposition And we'll stand on that testimony, but just briefly summarize here, since the previous testifiers really summed up the legal problem with this bill better than maybe some of us with law degrees can. But as we describe in our testimony, number one, this is just straight unconstitutional. It violates due process, which is a constitutional right, not only in the state constitution, but also the federal constitution. You can't eliminate contested cases any more than you can eliminate the right to vote or a right to a jury or Miranda rights. I don't see this question of constitutionality addressed anywhere in the bill or in any of the testimony in support. What's the legal basis for this? And so that's number one. This bill is DOA, just legally. Secondly, I can see how the bill is trying to address the issue of efficiency because, let's be honest, Earth Justice has represented community clients in cases and contested cases that go on and the entire time these community rights are not being recognized and the community is left hanging. So we understand a concern about contested cases being inefficient a lot of times. But the answer, of course, is not to eliminate contested cases. And in fact, this bill eliminating contested cases would make the whole process more inefficient and more burdensome because the whole point of a contested case is to streamline the process because the agency applies its expertise to specific facts according to due process. It makes a record, and based on that record, then parties can appeal to the courts and the courts apply a limited standard of review. So it's all an orderly process if it's done right and efficiently. And eliminating that process actually burdens the whole system and particularly the judiciary because it's going to be a free-for-all. And thirdly, as the previous testifiers pointed out, it undermines access to justice, really a fundamental principle and citizen participation in democracy. And so, that basically sums up our testimony. I'd like to be available for questions if anyone has any, but maybe that previous testifier on the previous bill, I actually have to run to pick up kids, and I'm not going to risk testifying from the road. But thank you. I'm available for any questions for a little while anyway. Thank you.
Okay, thank you very much. Richard Matsuda, Mauna Kea Observatories.
Aloha, Chair Nakashima and members of the committee. I'm Rich Matsuda with the Mauna Kea Observatories here in support of the measure, and thank you for the opportunity. I am not a lawyer, but I wanted to emphasize a key point of our testimony, which is about the timeliness of the process that was referred to by the previous testifier. And I just want to make it clear, we fully support fair and just land use decisions that consider the voices of the public. Our issue is about the time it takes to run through the process. So I wanted to explain a little bit about that. The master lease between the University of Hawaii and the state for the Mauna Kea Science Reserve expires in 2033. The observatories are sub-lessees, and we have been in operation for decades. And the majority of us want to continue operating beyond 2033, which requires a new lease. When this new lease comes to the BLNR for a decision, it will likely involve a contested case and court appeal. And like previous testifiers said, we know this can be a really lengthy process. It may seem like there's a lot of time between now and 2033 for that process to occur, but the observatories must have authorization much sooner, and here's why. Without a timely authorization for a future lease, number one, the future of our organizations and the 500 Hawaii Island resident staff will be clouded. Number two, the confidence of our funding agencies will be eroded. And number three, facility upgrades and technology development will be impacted. And I think any organization facing lease expiration would have similar concerns as these. But furthermore, for the observatories, without a future land authorization, we are bound by the current sublease agreements to decommission by the lease expiration date. And decommissioning is a lengthy process which pushes the clock back 6 or 7 years, meaning that we need future land authorization by around 2025. And there's a lot that needs to happen between now and 2025, including a likely contested case and court appeal. And so basically, due to these circumstances and the process, the Mauna Kea observatories are in a time crunch. And we feel that for something as important as the future of astronomy on Mauna Kea, we can't afford the lack of a decision to be the decision. And so time is a real issue for us and why we're supporting this measure. So just want to say mahalo for the opportunity and happy to answer questions.
Thank you very much. Wendy Laros, Kohala Chamber. Wendy, you're muted. Still can't hear you. Should we ask her to rejoin?
Wendy, if you're on a laptop, is there a microphone button that you can press on your laptop to enable your microphone? Should be in the top row somewhere. Okay. Are we getting some kind of feed from her? I see the yellow box around her.
Okay. Okay. So we'll move on and see if Wendy makes it back. Marty Townsend, Sierra Club. Not present. Bronson Kainoa Kiyoshi Azama. Okay. Deborah Ward.
Hello,
Hello.
my name is Deborah Ward. Aloha, Chair and committee members. Thank you very much for the opportunity. I strongly oppose passage of HB 344 because it sacrifices the opportunity for a member of the public with standing to present expert testimony and evidence for decision makers to hear prior to decision making. It would be rather difficult to think that one would be going to court before a decision, and it makes no sense what this bill proposes to do. The bill would preclude the creation of a record for either the decision makers or the courts to weigh in determining the outcome. And I speak from personal experience. I've had the opportunity and have demonstrated standing pro se to participate in 4 contested cases over the last 30 years. The outcome of 3 of these cases led to a significant protection of public trust, resources that would have otherwise been erroneously depleted. One of these projects was proposed by Albert He, who has notoriously shown himself to lack the interest of the public in his endeavors. I would also like to add, because I was a participant in the TMT contested case hearings, that it would have taken far less time if the hearing officer selected by DLNR had given our attorney the respect he requested regarding his prior schedule. As it was, we all represented ourselves pro se, without representation, and the hearing went on for far longer than it would have otherwise. There can hardly be judicial review if there's no record, nor are there limits of judicial review applicable in the absence of a record. And so the court would essentially be placed in the position of acting like a legislative body, which is a violation of separation of powers. Please do not assume that due to the COVID fiscal constraints, that the state's economic status would be improved by this bill. Deprivation of the public's opportunity to participate in contested cases could ultimately lead to deleterious effects that could further damage our economic situation as well as our environment. I urge you to allow the public to participate in a review that does not demand that a lawyer be hired, because many of the people who have very good rights to present evidence and documentation do not have the money to hire a lawyer, and the courts would require this. So I ask you to reconsider this. Thank you very much.
Thank you very much. Okay. Wendy Laros.
Can you hear me now?
Yes, we can. Congratulations.
Thanks. Sorry about that. Aloha Chair Nakashima and the House Committee on Judiciary and Hawaiian Affairs. My name is Wendy Laros. I'm the president and CEO of the Kona Kohala Chamber. Our chamber supports House Bill 344, which specifies that the Board of Land and Natural Resources shall not conduct contested case hearings regarding disputes over land use, but that those decisions will be contested and adjudicated in circuit court. With nearly 500 members, our chamber exists to provide leadership and advocacy for a successful business environment in West Hawaii. We believe that House Bill 344 has broad implications, potentially helping businesses across the state that are subject to lease renewals. We also support this measure because of its impact on Hawaii's astronomy industry and the impending master lease, which was already mentioned, the lease renewal. Although the lease expires in 2033, the timeline is condensed, as mentioned, due to critical junctures in the sequence of events. This legislation is crucial in creating timely action, as the lease renewal may be subject to a contested case and lengthy delays would impede the process. For Hawaii Island, the astronomy industry atop Mauna Kea creates jobs and economic impact, as well as educational opportunities that otherwise would not exist. The Kona Kohala Chamber of Commerce works to strengthen our local economy and promote the well-being of our community. We believe that House Bill 344 will enable a timely and effective approach to the existing process that will ultimately provide positive outcomes for our community and our state. Mahalo for the opportunity to testify.
Thank you very much. Deborah Ward.
I'm sorry, I've already presented testimony. Thank you.
Oh, I'm sorry. Okay. Lanny Sinkin.
He's not available. He's getting a vaccination.
Okay. Kamalani Uehara, I'm sorry. Candice Fujikane.
Aloha mai kako. Aloha mai, Chair Nakashima and members of the committee. My name is Candice Fujikane. I'm an English professor at the University of Hawaii, and I teach classes on land and water legislation and struggles in Hawaii. I strongly oppose HB 344. This proposal would do away with contested case hearings. And this is not new legislation. This came up in 2018 in House Bill 1565. And that bill was soundly defeated precisely because it proposes to extinguish the rights of the people to contested case hearings. And this is an opportunity for participatory government. This is a chance for the people to challenge decisions made by the Board of Land and Natural Resources and the Commission on Water Resource Management when they approve harmful permits for harmful projects. Without these contested case hearings, the citizens are not able to have their objection on record, and they're not able to use this record on appeal in a court of law. We all know that taking the cases to court is way too expensive for ordinary citizens. Now, this is really important. The fact that the governor of the state of Hawaii nominates and appoints the members of these decision-making bodies makes this process one that is subject to the political vagaries of the day. So we've seen under the Trump administration how precarious such appointments can be, and contested case hearings provide an important process of checks and balances to those precarities. And I just kind of want to say what I've heard at these contested case hearings are people saying that they have to step in when they feel that the Board of Land and Natural Resources is not doing its job, when they feel that the Board of Land and Natural Resources is not upholding conservation district laws. So those are very important things. I've heard Kalani Flores says, I'm doing the work that the Board of Land and Natural Resources should be doing. And so that's why these contested case hearings are very important. And listening to testimony in support of this bill by the observatories, representatives of the observatories, clearly what they see is this process of permitting as a simple hurdle instead of the question of whether these projects are just, whether the projects adhere to the law. And there's no concern about justice. Their only concern is for expediency and money. Okay, the people who put up these contested case hearings, they're using their own time. They're not being paid for these contested case hearings. It's a tremendous commitment for citizens to come forward and to call for these contested case hearings. You can clearly see the difference in terms of the interests on either side of this case. The telescope supporting House Bill 344 in the name of expediency because it's costing them too much money, and the people who are coming forward to say they will take time out of their daily lives, away from their jobs, away from their families in order to pursue these contested case hearings. So I just urge the committee to oppose HB 344. Thank you very much.
Thank you. Okay, that's all of the testifiers that we have on this particular measure. Members, any questions?
Chair.
Representative Lopresti.
Thank you. Is Earth Justice still here, or did he go pick up his kids? And Sierra Club still not here. All right. Well, I'd like to ask then perhaps Professor Fujikani and Ms. Ward a couple of questions, if that's right.
Okay.
I share a lot of the concerns about the constitutionality of this. I also share the concerns about the timeliness of it, and without, I don't necessarily agree that it's about money for just money for some of these people. I wonder what I think this bill is trying to achieve was articulated by the guy from Earth Justice, that it's trying to address the timeliness of it, that it can get drawn out. And Ms. Ward, you really clearly articulated that perhaps in the way that the contested case hearings are done, there are ways to speed up that process. Because what I'm not hearing from either side on this issue is speaking specifically to that issue without stripping away the people's rights to a contested case hearing. And that's a discussion the state desperately needs to have. And both sides, I think, need to contribute ideas to that. And I'm curious, does that resonate with you? What are your ideas to that end?
Debbie, you should go. Yeah.
Personally, the first contested case I took part in was back in the 80s with Honolulu Stream. And that was not a long drawn out process. We had a couple of days to present testimony. The testimony was efficiently presented and it did sway the decision makers, and there was a successful outcome. With the contested case in 2011 with regard to the TMT, that case took something like 7 days and was efficiently carried out, but the hearing officer took a little over a year to make a decision and present his decision to the DLNR. And at that point, there was an appeal. It did go to the Supreme Court and it was turned back. That's the reason that we were remanded to do a second contested case, which took an enormous effort of a huge number of people in the community in order to carry it out. For one reason, there are lots of reasons, but one of them was that the hearing officer refused to hear the request of the attorney that represented 6 of us to adjust the schedule in order to allow him to carry out his other responsibilities. Then there was no standing hearing, and so there was no way to establish who actually had standing in order to carry out their petition responsibilities within the hearing. So it did take 11 months and 44 days of hearings, which was extremely difficult for both the university, the TMT, and for all of us who participated pro se. It was probably unnecessary, and it was extremely disappointing. Both the hearing officer took absolutely not one fact presented by any of the 23 participants.
So let me ask this, Ms. Ward, if you don't mind me interjecting.
Of course.
So from that, whether it's part of this bill or in the future, are you able to perhaps extrapolate and maybe we can come up with new rules by which these things have to be done? Because I mean, I don't mean expediency in a bad way, but that's a real factor too. That people deserve to get back to their lives, and the people doing these projects deserve to either know yes or no, right? And so that would be really helpful, to have that. And Ms. Fujikani or Dr. Fujikani, I
Yeah. See, the reason why it was so protracted was because BLNR did not follow the rules. What they did was they made a decision on the permit and then they held the contested case hearing. That's why at the Supreme Court, ruled that BLNR had put the cart before the horse. They had not followed proper procedures. So you're right in that if BLNR had followed proper procedures, there would not have been 2 Supreme Court cases and 2 contested case hearings. But BLNR was trying to expedite matters by approving the permit and then having the contested case hearing. I think if the process had been followed, it would have been much more streamlined. As Debbie Ward was saying, it was not a very long process for the first contested case hearing.
Thank you. I know other members might have questions, and I don't want to take up all their time. Thank you, ladies, very much. Thank you, Chair.
Thank you, Representative. Members, any other questions?
Sure.
Representative McKelvey.
I apologize. I don't know who would be the one to ask this of. Maybe DLNR, if I could. They're still on?
She's over here.
Oh, okay. I guess I'll ask the question rhetorically in decision making then. Okay, sorry, Chair.
Okay. Okay, thank you, members. We move on to House Bill 601 related to traffic code. First, we have Alan Carpenter, DLNR.
Good afternoon, Chair. Jason Redula, DLNR's Enforcement Chief for the department. We'll stand on our written testimony offering comments. Thank you.
Okay, thank you very much. I also have Kurt Cortell and Jason Redula, also DLNR.
Hey, Chair. Good afternoon. Kurt Cottrell, Administrator for the Division of State Parks. As Jason, our enforcement chief, said, we stand on our testimony offering comments. Mahalo.
Thank you very much. Ed Sniffen, Department of Transportation.
Good afternoon. This is Lynn Araki Regan, Deputy Director for Department of Transportation. We stand on our written testimony and support. Thank you.
Thank you very much. Chipper Wichman, National Tropical Botanical Garden.
Aloha, Chair. Thank you for the opportunity to provide testimony. I did provide written testimony, which I stand upon in strong support of this. And I just want to say, if you look at the background behind me, this is a remote community that we live in Hyanna. And I worked for over a year with state parks, Care, KPD, all convened by Representative Nadine Nakamura. And it became very, very clear through that process that Care and KPD will never have enough manpower to enforce citations for cars parking in the no parking zone. I was really glad to see DOT supporting this. And it was really the consensus of this group that we needed to allow enforcement officers to focus on more significant things. And that if we could find a way to empower designated employees of the state or the county to be able to put the tickets on the cars, that would be in everybody's best interest. It would be a win-win. And I strongly hope that this committee will pass this bill. I know that Representative Nakamura has been working to address some of the concerns raised by the union, as well as by Care. And I hope that some form of this can move forward. Our community desperately needs it. We've been given a break by COVID on the onslaught of tourists, but it will come back. And when it comes back, we need to have more tools in our toolbox for dealing with it. Thank you very much. I'll be online if you need any questions.
Thank you very much. Joy Kuwabara.
Good afternoon. This is Joy Kuwabara on behalf of Randy Pereira of the Hawaii Government Employees Association. Thank you, Chair, Vice Chair, committee members for allowing me the opportunity to testify in strong opposition. We stand on our written testimony. Wanted to make sure that we reiterate what's in the testimony, that issuing citations for traffic violations is not a daily function for positions outside of law enforcement, and designating this task to other state or county employees significantly impacts an employee's condition of employment. Therefore, the terms must be negotiated and mutually agreed upon. It also raises issues of liability for affected employees and the jurisdictions. Also, contracting out this function, which has customarily and historically been performed by civil service employees, contradicts Chapter 76 Civil Service Law. And more specifically, law enforcement officers that are hired through the civil service process have been trained and possess the skill set to enforce and address any violations in accordance with law. Thank you for the opportunity to testify. I'm available for questions. Thank you.
Thank you very much. Yeah, members, that's all the testimony that we have on this particular measure. Are there any questions? Representative Ward.
A question to DLNR. Do not all of the county funds, or let's say all the traffic funds, go to the state and not the counties, or has that changed?
I think DOT is probably best suited to answer that question, Representative Ward. Okay. DLNR does not normally get involved in highway or traffic safety on public roadways.
Yeah, my understanding it goes to the state, and Representative from Kauai has just noted the same. So I'm not sure what incentive is there. And there are cost savings that somebody knows about that's on this call. I'm trying to see what the logic of it is. No, seeing none, Chair? Or
Can I answer?
Yeah, Representative Nakamura, why don't you answer Representative Ward's question?
This is not about the fines along, it's a state highway, basically on the North Shore. But State Highways Division does not have enforcement capabilities. They rely on the county. Because this is such a remote area, the Kauai Police Department will not send officers out there on a regular basis. So the issue is not about who gets the money. It's about doing the work of enforcement in a remote area.
Well,
And
I didn't say it, but my point is, if we don't fund the police, obviously this is going to happen. So we should not be not funding the police, so we don't have cases where it's so rare as this.
this is not about funding police. This is about giving the police chief in every county the authority to assign a
Non-policemen,
non-police, like a meter maid,
yeah.
to do the work. And apparently, according to state law, the currently under current state law, the police chief does not have that authority. So this bill tries to rectify that.
Okay, Chair, then the question is, what is the cost savings? What does it cost to contract this out versus getting, as I said earlier,
the idea-
funding to police?
Yes, the idea would be to remove any language relating to contracting it out, to just use county employees who are already there and can do the work.
But not doing the work that they're paid for because of
Here, can we cut this off and we'll take it to discussion after
Inside baseball.
after the
Yes.
hearing? Yes. Okay. Members, any other? Yes, Representative McKelvey.
I don't know if is HGA still on the line or are they?
Yes, I'm here.
No, the question is that, but this isn't new or unique, is it? Because like right now, we have state maintenance workers at all the airports who are doing travel screening and functions like that, which are not inside their area. So it's not, this has happened before where state workers have been asked to, you know, perhaps do things that may not fall solely within their scope, right? Or
I would have to go and check on that part. I'm not sure, but in regards to the enforcement in this, as I stated earlier in the testimony, law enforcement officers they're trained to do that, to enforce the laws and ensure that
the inspection at the airports. I mean, so the maintenance workers are the ones doing it now. So I just why I think the bill is a good bill, and so I just want to ask you that question. Thank you, Chair, for allowing me that question.
Okay, thank you very much. Members, any other questions? Okay, sensing none, we will move on to House Bill 567 related to employment. First, we have Cara Cabola Corolos, Hawaii State Commission on the Status of Women.
Good afternoon, Chair, Vice Chair, members. We are in support of this measure, the HD1, with a requested amendment. Just 2 days ago, President Biden declared that the crisis of women leaving the workforce because they don't have, clear access to telework and flexibility during school closures and childcare is an emergency. And I just want to state really quickly that I am not only sympathetic, but supportive to the issue of negotiability and HGA's, power. So we in no way intend to undermine that, but we still strongly believe that there needs to be a policy. And the amendment that we're seeking is at least temporarily, although we know that the temp policy is in place right now that permits caregiving and telework, contrary to the 2010 guidelines, that we really need to ensure that this is communicated in a way that's not confusing, because there is so much philosophical opposition from certain department heads all the way down to managers to allow accommodation for telework and caregiving. So we think that's really important just as a policy statement while negotiations are ongoing and as this is worked out. That's all I have, but thank you so much. And again, we ask that you pass this measure.
Thank you very much. Next, Riker Wada, DHR, heard.
Hey, aloha, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. Riker Wada from the Department of Human Resources Development. We're testifying in support of the intent of this measure for the LRB study. As the prior testifier noted, that this is, we believe, an area that's subject to negotiation, and its issues pertaining to the employees' wages and work conditions have historically been subject to collective bargaining between the employer and the exclusive representative. I'd be happy to answer any questions, and we'll stay on the line as such.
Okay, thank you very much, Mr. Wada. Cynthia Koval, DOE.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and committee members. I'm Cindy Covell from the Department of Education, and on behalf of Superintendent Kishimoto, we stand on our written testimony in support of this bill. We do see telework and alternate work schedules supporting our innovative strategies, and look forward to collaborating with the LRB as they do their report. Thank you. I'll be available for questions as well.
Thank you very much. Next, Ronnie Funakoshi and Ann Setogawa, Office of Planning.
Thank you, Chair. This is Aaron Setogawa from the Office of Planning. OP stands on its testimony and support.
Okay, thank you very much. That's all the testifiers that we have. Oh, I'm sorry. Randy Pereira, HGA.
Thank you, Chair. How could you forget about us? Michelle Kurihara Klein, on behalf of Randy Pereira, our Executive Director in the Hawaii Government Employees Association. You have our written testimony before you, which for edification does mirror a lot of what Dee Hurd suggests, which is a very rare occurrence for us to agree with management. But we do want to point out that telework policies are negotiable, and we would like them to remain that way. However, we are in support of the intent of this measure and the study. I'll be available to answer any questions should you have any. Thank you.
Thank you very much. Okay, now we are at the end of our testifier list for this particular measure. Members, any questions? Okay, seeing none, thank you. Thank you, testifiers.
Chair.
Representative Lopresti.
It's not a question so much as a comment, and I would like to, I can make it into a question if you need. I just wanted to state my support for the testimony to include in section 5 the statement about pandemic emergencies as noted by the Hawaii State Commission on the Status of Women. I think that's an excellent recommendation, and I hope you
Here,
add that.
we can bring that up during decision making.
Sure.
Okay. Okay, House Bill 670. Relating to the employees' retirement system. Thomas Williams, ERS.
The camera. Chair Nakashima, Vice Chair Matayoshi, members of the committee.
I'm Tom Williams, representing the Employees Retirement System. You have our testimony, and I'd like to stand on that testimony in strong support of this measure. And of course, I'm available to respond to questions that you other committee members may have.
Thank you very much. Sandy Ma, Common Cause.
Good afternoon, Chair, Vice Chair, members of the committee. We support this measure. This is not about retribution and punishment. This is about ethics and restoring the public's trust in government. Thank you.
Thank you very much. Okay, members, that's all the testifiers we have scheduled to speak today. Any questions? Seeing none, we'll move on to House Bill 98, relating to aquatic resources. We have Jason Redula, the LNR.
Good afternoon again, Chair and committee members. Jason Redula, the LNR's Enforcement Chief for the department. We'll stand on our written testimony providing comments. Thank you.
Thank you very much. Ian Garrard, DLNR.
Hello, Chair, Vice Chair, members of the committee. I'm sharing testimony with Enforcement Chief Jason Redula, and we're gonna stand on our written testimony.
Okay, thank you very much.
Thank you.
Brian Nielsen, DLNR.
Aloha, Chair. Standing on our written testimony. Thank you.
Okay, thank you very much. And then David is not here. Okay. And then Zachary LaPride, Ocean Tourism Coalition.
Good afternoon, Chair and Vice Chair, members of the committee. Can you hear me?
Yes.
Okay, thank you very much for the opportunity to speak and also for your service. I am representing today the Ocean Tourism Coalition, which represents about 300 ocean tourism businesses statewide. We originally flagged this bill not because we disagreed with the intent of the bill. Certainly, protection of aquatic resources is extremely important to the industry of ocean tourism. But we were concerned with the unintended consequences of the bill and offered up alternative language for the bill to the House when it was originally heard by the Committee on Water and Land in the House. We were very happy with the language they included to make sure there was a state of mind requirement that any violations of this bill require an intentional violation. But because the statute or bill could be so onerous, for example, a forfeiture of a vessel for any violation of the bill or possible criminal penalties, we ask that this committee review our testimony. We've included some additional language that we really think can make the bill a little more succinct and applicable to any violations of fishing, possession, or sale of aquatic life, and not to an unintentional grounding of a vessel or something that could occur by accident that really shouldn't bear the consequences of a forfeiture of a vessel and criminal charges. So with that, we will rest on our testimony, ask that you review it, and thank you very much for this opportunity.
Thank you very much. Okay, that's all the testimony that we have on this particular measure. Members, any questions? Representative Ward.
Thank you, Chair. Mr. LaPride, Zach, question.
Yes, sir.
What is a good example of some of the things that you fear may happen? Is this like if you get too close to a whale, you're going to lose your boat, etc.? what's the practical application?
A practical application, sir, would be if, for instance, an anchor by accident and unintentionally may damage coral reef. There are already statutes in place to handle that situation. In particular, 187A. And so what we're saying is that if it's that circumstance where it is unintentional, there really shouldn't amount to a forfeiture of a vessel or possible criminal penalties, but more the currently assessed fines for damages of specimen to coral and so forth. And so we really wanted to clarify that state of mind requirement. So if there's a captain working for a small business that mistakenly does something with an anchor, he's not subjecting himself to criminal penalties and also a forfeiture of the company vessel.
What are the fines now under the existing statute?
Well, it's a per specimen based on the square footage of coral you impact, but I can supplement our testimony with the exact assessment of fines if you prefer.
What's the average cost of your vessels that you represent?
We represent vessels that are on the full broad spectrum. We represent a 6-passenger vessel that could be worth $20,000, $30,000, all the way up to large scale vessels could be worth by many millions of dollars.
Okay, there's a lot at stake. Thank you very much. Chair, thank you.
Oh,
Okay,
Sure.
thank you, Representative McKelvey.
yes, Zach again, if you're still there. Hey, good to see you again. Long time. Hey, no, I'm looking at the committee report of the bill. I apologize. I don't have it in front of me, but it looks like the last committee amended it by making it the intentional state of mind. And under the examples you gave, it wouldn't rise to intentional at all. So I don't see how the bill as amended would now, would put your captains at risk of, in the case you gave and others, of being convicted and having forfeiture take place.
That's absolutely right. And we're absolutely appreciative of the Committee on Water and Land and the additions they made to the bill, in an effort to continually refine and adapt the bill to what we see as the intent, which really what I think was to prevent taking of fishing and aquatic specimens and stuff like that, that we include that language in the actual bill, which is during this round, after we've had further opportunity to edit and adapt the bill, we've included that suggested language in there, but we are certainly grateful for the intentional language that was included on the House version of the bill, HD1.
Yeah, because the intentional state of mind is the highest one. I mean, you have to go do, so in all those incidences, which would give me concern, you wouldn't have forfeiture take place. That's all. That's what I'm trying to, it looks like they've taken care of your concerns. That's all. But anyway, thank you, Chair. Appreciate the question.
Thank you very much, members. Any other questions?
Sure,
Representative Ward.
Could I do a follow-up on that? So, Mr. Prattle, if you went too close to a whale, how would I prove you did it unintentionally? Or that you didn't do it intentionally?
Well, first of all, I'm not certain that this would be a circumstance of there are federal laws that would apply to approaching and getting too close with a certain range of whales. But in this case, these are crimes that are included in the bill, including a misdemeanor, and all crimes in all our courts require a certain state of mind requirement, whether it's intentional, for instance, manslaughter is an example versus murder. But a state of mind requirement is certainly something that when you're issued a ticket in any court of law, you have to prove that specific element of crime. So, there are unintentional crimes out there that, for instance, strict liability crimes are unintentional and stuff like that. So I think that the state of mind requirement is something that isn't that uncommon.
Would this bill include aquatic fish or ornamental fish that people are harvesting and sending to the mainland?
Yes, that's part of it. Is what we're asking to include is to make sure there are violations are penalties assessed for the sale of aquatic life in violation of the statute.
So this may be aimed at them more than you guys then.
That's exactly what we're trying to avoid, sir, and that's why we are proposing this language, because we understand it to be a bill aimed at that particular industry of the illegal sale of aquatic life. But based on the drafting of the bill, we're trying to make sure that we are wrapped up in it.
It's just going in the back door. Okay, thank you very much. Thank you, Chair.
Okay, thank you, members. Any other questions? If not, we'll move forward to House Bill 465 related to collective bargaining. First, we have Riker Wada. D. Heard.
Hi, aloha Chair, Vice Chair, and members of the committee, Riker Wada. In this capacity, I'm sitting as the Office of Collective Bargaining. We will stand on our testimony in opposition and just note that there is concern that this bill diminishes the governor's authority by compelling him to appoint a single individual as opposed to from a list. If we have any questions, please let me know and I will be standing by. Thank you.
Thank you very much. Marcus Oshiro, Hawaii Labor Relations Board.
Good afternoon, Chair, Vice Chair, members of the committee. Midori Hirai on behalf of Marcus Oshiro and the rest of the Hawaii Labor Relations Board. We will primarily stand on our written testimony, but I did want to highlight two main points. There are two parts of this bill. The first one would change the way that the labor representative on the board is nominated. And that brings up the fact that right now, only one of the board's three constituencies are represented in determining who sits on the board. Roughly 50% of our cases in the recent years have been HIOSH cases, which we have appellate jurisdiction over. And yet HIOSH, as well as the businesses that they represent and the private sector unions whose members come before us, have no say in who sits on our board. So that's our first point. And then our second point is that neutrality is paramount to fairness when it comes to judicial and quasi-judicial decisions. The current language in the bill has the potential to remove the neutrality of one board member by making them beholden to a particular party. If that board member doesn't do what that party wants, they could be removed by that party without any actual cause and without any opportunity to defend themselves. So the board member's tenure would be reliant on doing what that party wants rather than on following the rule of law. If the legislature does want to institute a removal system for a board member and cares about the board's neutrality, then the process of removing a board member should go through a neutral body who does not appear before the board, such as the legislature, where that board member would have an opportunity to defend themselves rather than giving that power to a party that appears before the board. Thank you, and I'll be available for any questions.
Thank you very much. Randy Pereira, HGEA.
Thank you, Chair. Good afternoon again. Michelle Kurihara-Klein on behalf of Randy Pereira and the HGEA. You have our written testimony before you, which outlines the justification and reasons why HGEA, as well as the other 5 public sector unions, are in strong support of passage of this measure. I did want to, in listening to the prior testifier's testimony, I did find it a little curious that there's such a great concern about neutrality, because as you read through our testimony, you will see that the governor has the authority to nominate all 3 of the members of the board. This is, the amendments that we are proposing is not to, it is actually to create a little more fairness and balance, because as the governor serves as the employer in many cases, and to allow him or her to choose all 3 of the seats clearly creates unfairness in the process. So I just wanted to be sure that, the committee considers that point of view, that the governor does have purview in its entirety on all 3 of the seats. And so I'll be available to answer any questions or if you have any. Thank you.
Thank you very much. Okay, members, that's all the testifiers we have scheduled. Any questions? Representative Ward.
Chair, I haven't been able to find Marcus Oshiro's testimony, and I didn't hear whether it was for or against you. Do you have that? Or I just didn't get it. Or is Marcus Oshiro's representative on? Was yours opposing or supporting the bill?
We have strong concerns about the bill.
Concerns?
We have concerns. We are not completely opposed to the bill, but we do have concerns about it as it's currently drafted.
Okay, thank you very much. Thank you, Chair. Got it.
Okay, Thank you. Members, any other questions? Okay, seeing none, then we will move on to House Bill 244 related to land recordation. Joanne Williamson.
Thank you, Chair Nakashima, Vice Chair and Committee for allowing me to testify. My name is Joanne Williamson. I'm a licensed land surveyor for the state of Hawaii. I also am a board member of the Hawaii Land Surveyors Association. I stand by my written testimony in strong support of House Bill 2 recordation. Land or property is the largest investment that many of us will make in our lifetime. This bill ensures that lands are mapped in line with the existing requirements of the Hawaii Revised Statutes 502. That's existing regular system land. When land comes out of land court, it is in regular system and should be mapped as such. Thank you very much for hearing my testimony. I am available for questions.
Thank you very much. Okay, members, that's the only testimony we have scheduled for this particular measure. Any questions or comments? Okay, if not, we'll move on. Relate to aquatic resources. Brian Nielsen, DLNR.
Aloha, Chair, Vice Chair, members of the committee. We stand on our written testimony in support. Thank you.
Okay, thank you. Next, David Sakota, DLNR. Not present. Okay, thank you. And then that's all the testifiers we have for that particular measure. Members, any questions? Seeing none, we'll move on to, oh, and we are done. Okay. Okay. Short recess.
Later.
Okay, members, we reconvene for decision making. First up, House Bill 245 related to historic preservation. On this, I am going to recommend that we amend the bill using OHA's recommended amendments to ensure that Native Hawaiian historical places continue to be recognized. Members, any questions or comments? Okay, if not, then Vice Chair, House Draft 1.
The Chair's recommendation is to pass HB 245 with amendments. Chair and Vice Chair vote aye. Representative Ichiyama?
Aye.
Representative Kobayashi?
Aye.
Representative Lopresti?
Aye.
Representative Lowen?
Aye.
Representative McKelvey?
Aye.
Representative Nakamura?
Aye.
Representative Takumi?
Aye.
Representative Todd?
Aye.
Representative Tokioka?
Aye.
Representative Ward?
Aye.
Chair, your recommendation is adopted.
Thank you very much. Members, House Bill 344 related to government. Chair's recommendation is that we defer this matter. Moving on, House Bill 601 related to the traffic code. Representative Nakamura for amendments.
Thank you. The first amendment to address the concerns raised by DLNR, we're going to remove any reference to the state DLNR in the bill. So this will only relate to city and county employees. We're also going to remove language relating to contractors throughout the bill to address HGEA concerns. And would also note that any additional responsibilities added to employees would have to be worked out through negotiated agreements. That would be more of a committee note rather than any change to the bill. Those are the recommended amendments.
Okay, members, any questions?
Chair?
Representative Ward?
Chair, I appreciate the representative from Kauai's explanation. It's a good workaround. It's practical, but it also says that we need to pay more attention to the budget for the police. So instead of a no, I'm just with reservations.
Okay, thank you very much. Members, any other questions or comments? Seeing none, with amendments, Vice Chair.
Chair's recommendation is to pass HB 601, HD1 with amendments. Chair and Vice Chair vote aye, noting the reservations of Representative Ward and all other committee members present. Any members voting with reservations? Any members voting no? Okay, Chair, your recommendation is adopted.
Okay, thank you very much. Members, House Bill 567 related to employment. This started off as a full-blown survey of government entities and the telework processes that they were experiencing and going through. Right now, it's a study, and the Office of State Planning and the DHERD are kind of engaged in a work where you live study that's kind of looking across agencies and how people's experiences in teleworking. And so I think a study by LRB will probably be duplicative. And so I'm recommending we defer this matter. House Bill 670 related to the employees retirement system. Recommendation of the chair is to move this out as is. Members, questions or comments? Okay, Vice Chair, as is.
Chair's recommendation is to pass HB 670 HD1 as is, noting all members present, any members voting no, any members voting with reservations. Chair, your recommendation is adopted.
Okay, thank you very much. Next item, House Bill 98. Members, the chair did not realize the recommendation of the tourism, ocean tourism folks regarding an amendment. And so I'd like to have time to check with the previous chair on getting prior concurrence on this. So I will defer this to next week, Tuesday, at 2 o'clock in this room.
It's a triple referral.
No, it'll be a triple referral, but I have until the end of the week. House Bill 465 relate to collective bargaining. Chair's recommendation that we move this out as is. Members, questions or concerns? Okay, seeing none. Vice Chair, as is.
The Chair's recommendation is to pass HB 465 HD1 as is. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 244, land recordation. Members, the chair would like to include the effective date on this July 1st, 2021. Members, any questions or comments? Seeing none, Vice Chair with amendments.
Chair's recommendation is to pass HB 244 with amendments. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you. House Bill 498, Aquatic Resources. Again, members, I would like to defect date this July 1st, 2021. Any questions or comments? Okay, seeing none, Vice Chair.
Chair's recommendation is to pass HB 498 with amendments, noting the presence of all members, any members voting with reservations, any members voting no. Chair, your recommendation is adopted.
Okay, thank you very much. House Bill 838, the chair's recommendation is to pass this out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 838 HD1 as is. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay. Thank you very much. Finally, members, we have 4 bills that were deferred from last week, from last meeting. HB 341 related to administrative procedure. Chair defers this indefinitely. House Bill 1138, House Bill 1366, and House Bill 1096. Chair would like to continue to work on this, and so we will defer decision-making on this until next week, Tuesday, in this room at 2 o'clock. Okay. That there being no further business, the committee is adjourned.